At the core of today's event is our brand new corporate law practice within the Wolep network. In establishing this practice, our primary goal is to provide our members with a wide array of advantages and opportunities, such as collaborative projects, meaning that members of this practice can engage in projects that draw on their collective expertise, and also client sharing, professional development, business opportunities, and of course, networking and connections. We are also delighted to share that our webpage for the corporate law practice is now live, and we invite you to visit, to explore it, and to become part of this practice. Now we are here to kickstart our opening roundtable discussion on corporate law, delving into the topic of exploring the world of limited liability companies and joint stock companies. So I'd like to hand over the floor to my colleague, Theodor Burnar, who will provide you with further insights into our brand and content strategies and guide you through the agenda for today's roundtable. Theodor?
Thank you so much, Adelina, and thank you all for attending. As you are probably accustomed by now, I will be delivering a short presentation. I will try to keep it brief. There are a few slides, but I will skip through them as we speak. So allow me to share my desktop. Let me see if it allows me to do that. Okay, so not right now, it's blocked. Just a second. So Adelina, is it okay? No,
Yeah.
I'll stop sharing just a second and immediately share it again. Okay, so this is what I was trying to show you. So this is my presentation, which I'm sharing with you. It's a development update as of today, 24th of October, 2023. So we think it's a good occasion to catch up with what we've been up to in the last few months. So we invite you to stay tuned for this short and engaging session, hopefully. I referred to the past summer previously when Mrs. Lucia Vranesevic-Grbic, our member from Belgrade, Serbia, joined. And one of the questions we'd like to ask you is whether you know what we did last summer. Well, I will briefly respond. On June 20th, we launched the Wolep criminal law practice, as you can see now on your screens. And on July 26th, we hosted the Wolep webinar on electric vehicles and alternative batteries, courtesy of our esteemed colleague, Mrs. Vranesevic-Grbic. Thank you again, Lucia. That was a very interesting and very hot subject for this moment in time. But that was not all, because during the past few months, we also published 9 Wolep talks featuring Wolep members, which we will see further as we speak, that it enhanced the profile of our members and of our network as well. Because these conversations with Wolep members spanned 3 continents. We're talking about Europe, South America, and Africa, and raised our profile and their profile as well. I would like to stress the fact that it's a team effort, and we want to thank you again for your contributions, for getting yourselves involved, and for realizing this is the way to go, because we are building a community, and let me tell you, it really works. So thank you again. We also introduced during these past few months Wolep polls, which are surveys intended to help us learn about the state of the legal profession around the world from you, and to tune our strategy together, because as we previously said, it's a team effort. We also reached a very important milestone in our development, which is reaching 100,000 reads of lawyer-related content on wolep.com. We did it last month in September 2023, and we are very proud of it. But again, we have to thank you for the openness and for the fact that you understood how vital in this day and age it is to be open-minded and to answer to our inquiries. Going further, you can see on the screen 5 key benefits of Wolep for lawyers. I was talking about global exposure, about collaboration opportunities, about the fact that those articles that we publish are translated in major languages. You also benefit from having extensive promotion on multiple platforms of Wolep, be it LinkedIn, be it Facebook, be it Twitter or X as it's called now, and so on. We also have a brand new podcast, and I'll be speaking about it a bit later, and also fostering collaboration and knowledge exchange, which we are doing as we speak. So our pledge, as you can see on your screens, is to be competent, to do networking, to be consistent and coherent with our approach. So you are in good hands, and we want to emphasize that. And we are very proud to have you as members of our network. So this is a word cloud, which is synthesizing what we are doing and we are looking to do in the future as well. There's also an important announcement regarding the life of our network. The fact that, because many of you have asked me these past few days if we are in Italy, in Como. We didn't manage to do it because it overlapped with the summer holidays of many of our members. So this forced us to reschedule it for spring 2024. We'll do it. It's very important to meet in person, and we'd like to take this opportunity to invite you again to join us in Italy. It's very important to have a very clear idea of how many of our members will attend. And I would like to thank everyone present. I know Mr. Aminu, for example, was very interested in joining us. So hopefully we'll meet in the spring, Mr. Aminu. Of course, this also extends to the other guests. Details, including the conference date and schedule, are to follow after we have a clear picture and we can engage in conversation with the hotel, and we can rent the conference room as we know the exact number of lawyers who will attend. So again, if you'd like to join us in Italy, please contact Adelina. She's your best contact in the network to clear out the details and to make a clear commitment to participate. I'd also like to invite you to register your interest to be a guest on the second episode of our Wolep podcast, because the first experience in which we had as guests members from Italy and Bulgaria was a success. You can find our podcast right on our website. And I think we think that it's a very good occasion to highlight your accomplishments as lawyers, but also to highlight your legal knowledge. That is very important, and we'd like to have you on board for this second episode. So please contact me this time, because I am the chief of content. So we'd be more than delighted to have you. It doesn't have to be a single guest. We can do 2 or 3 more guests alongside me to speak about the state of affairs in law today. Moving forward, we also established at the start of this month the Wolep Law Firms practice, which is a very important milestone in our development. And this community is designed with your unique needs in mind. If you are part of a law firm, or if you maybe manage a law firm, so by joining this practice, you can benefit from the full potential of our network to amplify your reach, to enhance your reputation, and also to solidify your presence on an international stage. We will try to provide you with a focused environment which facilitates connections, collaboration, and exponential professional growth. And because we come to today's topic, we are very proud to establish this corporate law practice. It's a historic day for us. So thank you again for making this possible, for making it happen. You will see on our website, wolep.com, that you will find the live page of the corporate law practice. Adelina mentioned it a bit earlier. It's live and you can check it out. I included a screenshot, a snapshot of this page as we speak, and below the image you can find a link to the corporate law practice. And my last announcement is that post-event, we will create, as is customary by now, the corporate law practices WhatsApp group, and we will make sure to add you, of course, if you agree to do it. It's a very fast-paced environment today, and everyone uses communication tools. So it's very important to stay in touch also via social channels. That was my presentation. I invite you to talk some more, either via email or via other channels by directly contacting us, whether it's Adelina, whether it's Romeo Cosma, whom I salute. He also joined us for this event. He's the, like I always say, the brains behind this project. And again, your humble colleague thanks you for joining us today. I will now lend the floor to our esteemed host today, Miss Carmen Cârcotă. And I would like to say a few words about her. She is obviously a corporate law specialist. She is the coordinator of this practice, and she has provided trusted legal assistance to both local and international individuals and companies across various legal spheres. So without further ado, I would like to thank you and to invite Carmen to take over from here. Thank you.
Thank you very much. Thank you very much, Theo, for the introduction. Good afternoon, everyone. I am excited to have the opportunity to give this presentation, and I hope to provide you with interesting information about the companies in Romania and the main components related to their establishment and organization. So my name is Carmen Cârcotă. I am a member of Bucharest Bar and a senior associate at Cosma and Associates, a law firm in Bucharest, and I have almost 8 years of experience in legal field. From the beginning of my career, I have been mainly involved in corporate and commercial field and also real estate, where I have assisted both local and international clients in various projects. So this is about me, and before we move on today's topic, I'd kindly ask the new colleagues who never joined Wolep Zooms before to say some words about them. Mrs. Anna Minoska, for example, could you please tell us some words about you? I think the microphone is closed.
Yes, you're right. Okay, you can hear me now.
Yes.
Okay, I'm happy to be here. I can see you already know each other. I find new one here, but I hope we will enjoy many other meetings honestly speaking, I have to mention that I had some experience with my clients from Romania, so I really had very nice memories from work with Romanian clients, and I'm especially happy today that I meet another Romanian colleagues. So I'm here working in my law office. Previously, as young lawyer, I used to work for one, let's say, famous and good established law firm here in Skopje in Macedonia. Then after from 2006, I have continued in my personal law practice. Me also, I'm doing mostly corporate issues, mergers and acquisitions. And let's say that's my special part of the law that I practice. Although in Macedonia it's a little bit difficult, but that is my, let's say, most of the work I'm doing here. It's the same I do with a lot of international clients, usually the foreign investments here in Macedonia. So I will be glad to learn from your experience what you will mention today. If you find something interesting from Macedonia, do not hesitate to contact me and ask whatever necessary. I mean, everybody in the group and in Wolep, let's say, collective of us as lawyers. Thanks, everybody.
Okay. Thank you very much. I'm very glad to meet you.
Me also.
Okay, so as a first step in today's discussion, I will begin by sharing a few words about the economic context in Romania. We can start the slide, please, the PowerPoint. Okay, so at this moment, the Romanian legislation is favorable to foreign investments and economic development. The tax legislation is attractive. The corporate legislation is adapted to the needs of the economic development, and the banking system is dynamic and offers financing opportunities for business development. In the recent years, the sectors that have stood out and provided the most business opportunities have been IT, real estate, infrastructure, automotive industry, but also the manufacturing sector. Okay, in Romania, traders, economic operators, as well as any other person authorized to carry out economic or professional activities are named professionals. Therefore, the professionals include all legal firms for conducting economic and professional activities, such as companies, authorized natural persons, and enterprises. But today's discussion will focus on companies. In Romania, there are 5 types of companies divided into 3 categories based on their nature. The first category is the capital companies, which are formed by a large number of shareholders imposed by the needs of the share capital without taking into account the personal qualities of the shareholders. So the essential element here is the share capital and not the qualities of the shareholders. In this category, we have joint stock companies and the limited partnership with shares. This type of companies, considering the big amount of the share capital, is good for large-scale businesses that requires substantial capital. The second category in the personal companies, which are formed by a smaller number of persons on mutual knowledge and trust, as well as the personal qualities of the shareholders. In this category, we have the general partnership and the limited partnership. Considering the personal qualities of the shareholders, typically these companies include a smaller number of shareholders and are suitable for small businesses in which the shareholders are actively involved in the businesses and undertake all risk of that business. The last category of companies in Romania is the mixed companies, which combines elements from both the capital companies and the personal companies. And from this perspective, in Romania, we have limited liability companies. This type of company is suitable for minimum-sized businesses that require a certain amount of capital, but also at the same time, personal qualities of the shareholders are also important. This being the factor that lead the shareholder to establish the company. Among all these types of companies, the most common ones in Romania are the joint stock companies and the limited liabilities companies, but mostly the limited liability companies. This classification of the companies in Romania has certain consequences. For example, in personal companies where the personal factor is really important, the contribution of the shareholders to the share capital can also be in labor. On the other hand, in capital companies where the personal factor is irrelevant, the contribution of the shareholders can only be in cash or in kind, excluding the contribution in labor of services. Additionally, another consequence is along the role of the personal factor, which means that the personal companies have stricter rules regarding the transfer of shares, which can be approved only if voted in the general meeting of shareholders with a certain majority required by law. In the absence of personal factor, capital companies benefit from much more favorable regulation. Hello.
Que no quieren el tasador, quieren tasador nombrado.
Okay, so I was saying that in the absence of the personal factor in the capital companies, the regulation for transfer of stocks is much more favorable. So this is a general overview of companies in Romania. What is to be noted is that the most common companies here are the joint stock companies and the limited liability companies. Now, to make the discussion more dynamic and interactive, I believe it would be useful and interesting if some of you could present the types of companies in your countries and other relevant matters.
Can I start?
Who would like to start? Yes, please.
Yes, I can start. I just looked in the Serbian Company Act to see if I'm right. So in Serbia, we have like almost everything the same except the limited partnership with shares. We have a joint stock company and limited liability company as capital companies. So it's not a mixed company. And personal companies are general partnership and limited partnership. So I find this mixed type really interesting. So someone else can go now. I don't want to take time. Thank you.
Thank you very much. Anyone else? Okay, do you have any questions about this section of our discussion?
It's Anna asking, maybe I didn't hear, I don't know, did you mention what is the minimum amount for establishment of limited company in Romania?
Yes, I will get there. The minimum share capital now is 1 leu, Romanian leu, which means 20 cents, euro cents. Okay, but in the past, the minimum share capital was 200 lei, which means almost 50 euros. Okay, but this condition is not available at this moment because the share capital should have only one leu. This is for the limited liability companies.
For the limited. Okay.
Well, good afternoon. I would like to introduce myself. Very nice to be here with you. I am Antonio Munoz de Gisbert. I'm a Spanish lawyer, member and partner of Apsis Legal. Hello, Adelina. How are you?
Hello.
Hi, everybody. I'm really glad to be here with you all. Can you tell me more or less what you've been talking about?
I was presenting the types of company in Romania, and I was saying that in Romania, the companies are formed of three categories. We have capital companies, in which category we have joint stock company and limited partnership with shares. I was saying that in this category, the contribution to the share capital is very important and not the personal qualities of the shareholders. The second category is the personal companies, in which the quality of the person is more important and not the contribution to the share capital. In this category, we have general partnership and limited partnership. And the last category is mixed companies, in which we have limited liability companies, and which is a hybrid between the first two categories, meaning that the contribution to the share capital and also the qualities of the shareholders are important.
All right, thank you very much. I would like to know who is in this meeting. As I told you, I'm Antonio Munoz. My name is not written very well anyway. I'm the lawyer of a law firm called Apsis Legal. We're based in Barcelona, and we can do all kind of legal work in all of Spain. So very nice meeting you all.
Thank you very much. Nice to meet you. Nice to meet you too. Okay, can we move forward? Okay, the next topic of our discussion is the conditions for establishment of companies. In Romania, all companies must have an article of incorporation in order to be established and operate legally. This article of incorporation is concluded between all shareholders of the future company before its establishment, and it is submitted to the trade registry as part of the registration file. As regards the formal condition of the articles of incorporation, it is valid when concluded under plain signature. However, according to Romanian legislation, there are specific cases provided by law in which cases the article of incorporation must be notarized by a public notary. And these cases are when a immovable asset is subscribed at the share capital, or when the company is formed by as a general partnership or a limited partnership. In terms of mandatory clauses of the articles of incorporation, the law provides certain clauses that must be included in the articles of incorporation. And these clauses are largely common for all types of companies. So we have clauses as regards the identification of the shareholders, identification of the future companies, meaning the name of the company, the legal form of the company, and the registered office. The articles of incorporation should also mention the object of activity of the company, the duration of the company, the share capital, with mentioning the contribution of each shareholders. The articles of incorporation should also mention about the management of the companies, the name of the directors and their responsibilities, the rights and obligation of the shareholders, and clauses regarding the dissolution and the liquidation of the company. As regards the substantive condition of the articles of incorporation, in order for to be valid, it is necessary for all shareholders to give their valid consent for the establishment of the company and the signing of the articles of incorporation. In Romania, this means that the shareholders need to have a full legal capacity, meaning that they must have reached the age of 18 years. and not be under judicial interdiction. As regards the number of shareholders, the law stipulates that a limited liability company can be established with only one shareholder, and the maximum number of shareholders is 15. For the rest of the companies, the law provides minimum 2 shareholders and doesn't provide the maximum number of shareholders, meaning that the rest of the companies can be established with any number of shareholders. Additionally, the law provides certain conditions for the person who can hold the capacity of shareholders or director of a company. Therefore, the shareholders or directors cannot be a person who have been placed under judicial interdiction, or a person who have this interdiction established by a final court decision. Another condition for establishing a company is having a registered office. The registered office must exist at the time of the company establishment, and its address must be mentioned in the articles of incorporation. The registered office must be within the territory of Romania, and if that space related to the registered office, if it is not owned by the company, it can be held under a lease agreement or a free lease agreement. As well, according to Romanian legislation, the registered office can be also established at the office of a lawyer, but not more than 1 year. Another important element for establishing a company is the object of activity. A company can engage in any activities from the classification of activities in the national economy, of course, while complying with the legal condition where applicable. Most activities can be carried out without requiring prior authorization. However, there are few activities that requires authorization before establishment, such as credit institution, banks, activities related to the production, import, export, and trade of firearms and munition, and companies providing accounting services. So these are cases where the companies should have prior authorization before submitting the registration file with the trade registry. As regards the share capital of the companies, it must be established when at the registration of the companies. The Romanian law provides for several types of contributions that can be made to the share capital. So we have cash contribution, which involves a sum of money that the shareholders undertakes to transfer to the company. And this type of contribution is mandatory for any type of company. As well, we have contribution in kind, which involves a specific immovable or movable assets. And this kind of contribution are possible for all types of companies. The last type of contribution is contribution in industry, which involve labor or services provided by the shareholders. And this kind of contribution is possible only in the case of general partnership or limited partnership, so in case of personal companies. One final matter to determine when establishing a company is the ultimate beneficial owners, who are the natural person who ultimately owns or controls the company. According to Romanian legislation, a company can be registered in the trade registry only if the ultimate beneficial owners are declared. This condition is recent, having been introduced in 2019. Okay, so these are the condition for the articles of association. As regards the incorporation procedure, for a company to legally be registered and operate, it is necessary that this company to be registered with the trade registry. The registration procedure of the trade registry involves the submission of a registration file that must contain the documents required by law. such as the article of incorporation, statements from the shareholders and directors confirming compliance with the legal condition of this for these positions, statement regarding the ultimate beneficial owners, as well as other specific forms and application of the trade registry. After the trade registry verifies the registration file, the company is registered in the trade registry, and this procedure takes 3 days if the trade registry is not requesting for additional documents. As regards the fee for registration, the trade registry fee is about 25 euros. So the registration taxes are very low in Romania. Usually, of this procedure of registration, an attorney or law handles the establishment formalities, including the preparation of the necessary documents and registration with the trade registry, as they can provide the legal support needed for the lawful legislation. Okay, so this is this was another point of our discussion. If anyone if anyone has any questions about the registration conditions in Romania, please. Okay, Mr. Antonio, could you please tell us a few words about the registration procedure in Spain? Mr. Antonio, can you hear me?
Hello,
Okay.
can you hear me?
Hello. Yes, I can hear you now.
Okay, excuse me, what was your
Yes.
question?
I was asking which is the procedure for registration of a company in Spain?
The procedure of registration
Yes.
of a company in Spain. Well, in
Yes.
Spain, what you have to do, there is usually it has been really with a notary. What you have to do is an incorporation of the company by the shareholders, and they have to go to notary and incorporate the company with all the requirements of paying the share capital and determining who's going to be the administrator, either one sole administrator, manager, 2 or 3, or a board of directors. Okay. Then when you go to the notary, you will have to sign the deed, the public deed, and with that you can go directly to register it in the Register of Commerce and of Companies. We have one, that means several registers in every province in Spain. Okay. And that's it. That's the classical way to do it. I know now I have to study that there's the possibility also to do it online, but I haven't had yet the experience. So I will tell you later when I can. Okay. Thank you very much.
Okay. Thank you very much.
Excuse me, can I ask a question, please?
Please.
Something fell to my mind. So when we're incorporating a company, you have to choose a business name. I'm asking this only because I had a case like this and a problem that was resolved afterwards. When you choose a business name, so it has to differ from all other business names and companies from the same branch of business or from each branch, and in how many characters it has to differ in Romania. I'm asking this because I had a case where the owner chose a name, and the problem is that I found out that the practice of the Serbian register is that it has to differ in 3 characters from every registered business, no matter of the branch of business it is in.
Okay, so the reservation of a name of the company is the first step of the registration, because with this name, all the documents for registration are prepared. So in Romania, yes, the name of the company should not be the same. So it can be only one company with the same name. And the similarity can be avoided if, for example, it is added another word or letters in order to be distinctive of another company's name. As regards, irrespective of the branch of activity, the name should not be the same with another company already registered in the trade registry.
Okay, thank you.
You're welcome. Okay, any other question?
Can I
Okay,
ask you,
please.
Carmen, regarding the managers or founders, any limitations for foreign persons, foreign individuals? I
No, we
believe
have no
not, because
limitation.
it's Europe. Sorry? No.
We have no limitation. Any
Oh.
foreign person can be director or shareholder in a
Mhm.
Romanian company.
Mhm. Okay.
Okay, any other question? Okay, we will focus now our discussion on the two most common types of companies in Romania, the joint stock company and the limited liability company. The first one, joint stock company, is the most complex and advanced form of company in Romania. Regarding the share capital of this company, it must be at least 90,000 lei, which means 18,000 euros, and it is formed by contribution of the shareholders. A joint stock company is established by the full subscription of the share capital by the shareholders. However, the capital actually paid at the time of establishment cannot be less than 30% of the subscribed capital, and the remaining subscribed capital must be paid within 12 months from the date of company's registration, or within 2 years, depending on the type of contribution in kind or in cash. The stocks represent titles of the shareholders' contributions and are fractions of the share capital that grants the shareholder the status of shareholders, along with the rights and obligations arising from this status. One of the classification of the stocks is based on the way of identifying the holder. And stocks from this perspective can be nominative stocks or bearer stocks. In case of the nominative stocks, the rights and obligation associated with the stocks can only be performed by the registered shareholders. On the other hand, in case of bearer stocks, the rights and obligations are belonging to the possessor of the stocks. Shareholders have certain rights and obligations provided by the law, such as the right to participate in general meetings of shareholders, the right to vote. Each stock carries one vote. They also have the right to be informed about the company's activities and have the right to dividends. The general meeting of shareholders is the decision-making body of the joint stock company, comprising all the shareholders. The general meeting of shareholders expresses the collective will and decides on all issues within its legal competence. General meetings of shareholders in joint stock company can be ordinary or extraordinary. The general meeting is convened at least one time a year, and the ordinary general meeting of shareholders is obligated, among others, to approve the financial statements and to choose and revoke members of directors. For sure, the ordinary general meeting of shareholders has other responsibility provided by law. The extraordinary general meeting is convened exceptionally when an important decision needs to be made, which often involves amending the articles of incorporation. For example, the extraordinary general meeting can decide on changing the legal form of company, so from joint stock company into limited liability company, for example, changing the company's registered office, changing the company's object of activity, or increasing the share capital. As regards the management of the joint stock companies, according to Romania law, there are two types of management systems. We have unitary system and the dualistic system. As regards the unitary system, it is when the company is managed by one or more directors. If there are multiple directors, their number must always be odd. And if a company is managed by multiple directors, they will form a board of directors. It should be noted that during the mandate, the company cannot conclude an employment agreement with the directors, and the relation between the company and the director will be regulated by company's law and the rules applicable to the mandate contract. As a general rule, the board of directors is responsible for carrying out all acts necessary and useful for the achievement of the company's activity, except for those acts that are reserved by law for the general meeting of shareholders. Additionally, the board of directors represents the company in relation to third parties. Okay, the second type of management is the dualistic one, under which the company is managed by both a board of directors and a supervisory board. Also, in this case, the board of directors can have one or more members, and if there are multiple members, their number must be always odd. The board of directors in the dualistic system has the same responsibilities as the board of directors in the unitary system. Namely, it is responsible for the management of the company and carries out acts necessary and useful for the achievement of company's activity. Additionally, the board of directors in dualistic system represent the company in relation to third parties. The second body of the dualistic system is the supervisory board, which is composed of 3 to 11 members. And this supervisory body has control related responsibilities with respect to the activity of the board of directors. Okay, before moving forward to the limited liability companies, do you have any questions about the joint stock companies?
If I'm allowed to intervene a bit, Carmen, thank you.
Please.
So I'm very glad that we are seeing new faces within our roundtable. A special thanks to Mr. Antonio Munoz de Hispert for his presence today. And what I would like to underline is the fact that, you know, every time we talk about our community and our network, we emphasize the collaboration aspect, the fact that as members, we can recommend another colleague from another country or another continent. So what I wanted to underline is the fact that it is very important for us to get to know each other through these roundtables and webinars and to share practical informations on the basis of which we can then initiate discussions with our own clients when we recommend another colleague from another, like I've said, territory. So it's very important to have distinct knowledge of the legal happenings in that specific country and to be able to know personally someone of trust whom we can recommend. So I think that is the principal gain of such events. Thank you again. I will let you take over again, Carmen.
Okay, thank you very much. Okay, Mrs. Lucia, can you please tell us a few words about joint stock companies in Serbia?
Sure. It's almost the same. So there is really no difference. You said everything. I was thinking about the question and I couldn't find something. Maybe the only thing I would like to point out in Serbia, I'm sorry if you already talked about that. I don't really remember. Is that a joint stock company needs to have a memorandum of association next to the articles of incorporation. So that's something I think that is an information that is valuable. Everything else is practically the same.
Okay, this is different from Romania, because in Romania it's necessary or only the articles of incorporation. So it's useful information.
Yeah, that's very interesting because for like the limited liability company, you only need to have the article of incorporation. But when it comes to joint stock companies, it is important that the company also has a memorandum of association. It's prescribed by the law. So
Okay,
that's like a fun
interesting.
fact from Serbia.
Okay, and the minimum share capital, which is the amount of it.
It's okay. I need to calculate now. So it is
Okay.
3 million Serbian dinars. It's around I think 20,000 euros, something like
Okay,
that.
so
So I'm doing this from my
similar
head.
to
So
Romania.
yeah.
Okay, thank you
And I
very
wanted
much.
to point out, sorry, can I say just something
Please,
else? Sorry
yes.
for interrupting you. When you talked about the limited liability company, I know this is upcoming, but the colleague asked you about the minimum share capital, and you said it's very low. It's the same in Serbia. It's 100 dinars, which approximately equals €1.
Oh, okay.
So also fun fact. So okay, I'm
Yes.
finished. Continue. Thank you.
Thank you very much. Okay, Mr. Aminu, can you tell please some words about the companies in Rwanda?
Okay, thank you so much. We have here a Company Act Direct 2021, and according to that law, we have 5 types of companies here in Rwanda.
Okay.
That can be actually incorporated. We have a company limited by shares, limited by guarantee. It can be both limited by share and by guarantee. And the fourth one is can be an unlimited company. And the specificity here in Rwanda, we have what we call a protected sale company. So basically, it's almost the same procedures to when it comes to set up a company. We have those 5 types plus the subsidiary that one might actually set up for the clients. And in relation with the shares, we have the shares actually according to those company can be ordinary or redeemable or confer preferential right to distribution. Shares have five classification. The third one that I just mentioned. The fourth one can be conferred by special, limited, or conditional voting rights. And the last one could be no confer any voting rights, actually. For these companies to be incorporated in Rwanda, we have here what we call Rwanda Development Board. I mean, everything is done remotely online, actually. And this organism is the one in charge of incorporating companies in Rwanda. So depending of the type of the company, You can have the articles of associations or not. If you have articles of association, they must be notarized in front of a notary,
Okay.
so that you can introduce within the system the Rwanda Development Board website. And once this process is done, it usually takes 6 hours to get the registration certificate. And they deliver also what they call the TIN number, the tax identification number, which is specific to every company. So I think globally, this is the process here in Rwanda. Thank you.
Okay, thank you very much. And the lawyers are involved in this registration procedure?
Yeah, lawyers could be, because actually, if a lawyer is involved, lawyer must need to have the power of attorney delivered by the client.
Okay.
The client must do it by himself or by itself. So, depends. But usually clients prefer to give this responsibility to lawyers when it comes to draft articles of associations. It's kind of complex matter to deal with. So yeah, so usually they give the power of attorney to the lawyers to handle the process and to follow up and to deliver them the registration certificate at the end of the process. So that's how it goes here.
Okay, thank you very much. Mrs. Anna Minoska, few words about the registration and the companies in North Macedonia. Sorry, I cannot hear you.
Yes. Regarding the registration, I was a bit surprised that in Spain, they've just started the online registration, because in Macedonia, we are practicing it for, let's say, a couple of years already. Anyhow, it's very similar to your process. It's some standard procedure. Usually, lawyers are authorized agents to register the company. So generally, the registration goes through the lawyers for formal registration. It's more or less the same as you mentioned. There is preconditions, everything to be prepared in advance. Then the process of registration takes for about 5 working days, 3 to 5 working days. It's prescribed for 5 working days, but it's usually finished earlier, except in cases when the registry is asking for some corrections or some additional evidences. So it's formally it's very easy procedure, but it's preparation process. It also takes some time, because we also have to prepare the general documents like the corporate acts, some statements to be prepared. But the easiest part is here that we usually do everything like lawyers with electronic signatures. So everything is confirmed by us, which means also the, let's say, bigger responsibility for us as lawyers, because we are the parties who are responsible for the evidence for the company, which is also very important. It introduced to us as an obligation, and with us the process of registration of final owner goes at the end. After the registration of the company in the corporate registry, it goes to the other registry, but everything is really fast forward. If it's ready, if it's correct, and there are no, let's say, additional questions from the registry. So very standard procedure based on European standards already.
Okay.
Mostly in practice, it's limited liability companies. Let's say the majority of the companies and majority of the practice, it's limited liability companies established here.
Okay. Thank you very much. Okay, so we will move forward to the limited liability company, which is the most common type of company in Romania. As mentioned at the beginning of our discussion, the limited liability company is a hybrid that borrows characteristic from both personal and capital companies, which means that they are based on both the personal qualities of the shareholders and the value of their contribution to the share capital. Regarding the share capital, the law does not specify a minimum. However, since the capital is divided into equal shares, and there must be at least one shareholder, in the case of a limited liability company with a sole shareholder, the share capital should be in amount of minimum 1 leu, which means 20 euro cents. So a very small share capital. The articles of incorporation of a limited liability company must specify the number of shares as well as the number of shares assigned to each shareholders for their contribution to the share capital. The number of shares is proportional to the contribution in the share capital, and each share gives the right to one vote in the general meeting. As in case of a joint stock company, the general meeting of shareholders is the decision-making body of the limited liability company. It expresses the will of the company and decides on all essential matters related to the company's activity. Therefore, the general meeting of shareholders decide on ordinary issues in the life of the company, as well as on some other matters, such as the changes to the articles of incorporation. The management system of a limited liability company can be carried out by one or more directors. Unlike joint stock companies, where the number of directors must be odd, in the case of a limited liability company, the number of directors can be also even. As for the responsibilities of the directors in a limited liability company, they are established by the shareholders in the articles of incorporation. Often in practice, directors of a limited liability companies are given the same responsibilities specified by the law for the board of directors of a joint stock company, along with the other various responsibilities depending on the needs of the respective company. If there are multiple directors, the articles of incorporation will specify as well how they will work, either jointly or individually. In case the directors work jointly, then the limited liability company can also be represented only by both directors. So as you can see, the legislation as regards the limited liability company is more reduced than in case of joint stock company, which is the most complex form of company in Romania. Okay, any question about the limited liability companies in Romania? Mr. Antonio, can you please tell us if the limited liability companies have the same regulation in Spain as in Romania?
Yes, in general, I would say they have almost the same regulation. I haven't been preparing slides of it, but there's no many differences.
Okay, which is the minimum share capital?
You have two types of corporate limited companies. These are what it's called Sociedad de Responsabilidad Limitada. That's limited liability company, and that's the most used in Spain nowadays. And the minimum capital has to be 3,000 euros. And
Okay.
there's another type that is for bigger companies, which is called Sociedad Anónima. It means no name society, which means that you can have shareholders that are not identified. And all these were this kind of company was the companies that were usually incorporated long time ago. And we have lots of SA, means Sociedad Anónima companies, and its minimum share capital is 60,000 euros.
Okay.
There's some difference between the two types, but mostly, as I told you before, right now, mostly the 95% of the companies are incorporated under a type of Sociedad de Responsabilidad Limitada.
Okay, thank you very much.
To you.
Okay, the last topic of our discussion is the most common post incorporation operation. In Romania, the most common operation are the transfer of shares or stocks and the increase of the share capital. As regards the procedure for transferring the stocks in a joint stock company, the ownership of stocks is transferred by a mention made in the shareholder registry. Therefore, there is no need for publicity of the transfer of stocks, and the transfer will be valid without being registered in the trade registry. As for the transfer of shares in a limited liability company, it can take place both among shareholders and persons outside the company. The only difference is that when it involves persons outside the company, the transfer must be voted in the general meeting of shareholders, and it has to be approved by the shareholders representing 75% of the share capital. So unlike a transfer within a joint stock company, in a limited liability company, for the transfer to be binding on third parties, it must be registered within the trade registry. So it is not fully valid if not registered in this registry. The second most common operation during the operation of the company is the increase of the share capital, which can occur in the same ways for both types of companies, naming by issuing new stocks or shares, or increasing the nominal value of existing stocks or shares in exchange for new contribution in kind or in cash to the share capital. Another way to increase the share capital is offsetting due claims held against the share against the company with its stocks or shares. So these are the most common operation after the registration of the company, and I will be curious about these procedures in your country. Who wants to say?
I would just shortly say that it's fully the same. It's all that you mentioned could apply here as well. It's fully the same.
Okay. Mrs. Lucia?
I wanted to add that it's also all the same. I have nothing interesting to add to this. So,
okay, thank you very much. Okay, so in general terms, this is the regulation of commercial companies in Romania. What should be noted is that Romania is a favorable environment for business, and the legislation provides adequate tools for various economic activities. Another factor that makes Romania a good country for the business environment is the fact that the lawyers are very well prepared, offer high quality legal services, and operate in all business area. Lawyers are involved not only in the process of establishing a company when the foundation of the business are laid, but are also involved during the operation of the company by providing legal consultancy to ensure that the business runs smoothly. Okay. Any other questions about the presentation?
I have no question. I just want to tell you that it was very nice, very kind and very short, and we still understood everything. What is, I mean, very important, like basic, what we need to know. And at the end, we can conclude it's very the same in all our countries.
Okay, thank you very much.
I also don't have a question, but I just would like to thank you for this presentation. It was very insightful.
Thank you very much.
Okay, if I'm allowed to have a short intervention, I would like to thank our speaker and our practice coordinator, Ms. Cărcotă, for her very insightful presentation. We were glad to see that, as she mentioned at the beginning, it was very dynamic. We had many of our guests involved in talking about the key legal considerations, especially entrepreneurs should keep in mind when deciding between forming a limited liability company or a joint stock company for their business. And this is where your knowledge, your specialized knowledge as lawyers is best placed in delivering high quality legal assistance. So I think we can conclude that this was a very successful roundtable. It gives us ideas for future events of the practice, and I take the opportunity to encourage you to come forward because you attended, and I'm sure that there were many ideas that sprung to mind today to come forward with proposals for the next meeting of our practice. It was very good to see you and hear you today, and again we'd like to take the opportunity to compliment you for this. Have a great evening, and we'll be in touch. Me and Adelina will make sure that you will be provided with a recording of this meeting, but also with Carmen's presentation. And again, thank you for this very successful event. Have a great evening. Bye-bye.
Have a great evening.
Bye.
Bye.
Thank you. Bye.
Bye.